Hi everyone, my name's Haydon Potter and I'm the head of our employment and workplace team here at Roberts Crosby Mortons and Lawyers. I'm here with my colleague Mitchell Hickey, and we're here today to provide a short video on one of the big ticket items from the 2022 federal election, being the changes to the industrial relations laws. On 2 December 2022, the federal government passed the Fair Work legislation amendment, being the Secure Jobs, Better Pay Act. In our view, these are the most significant and substantial changes to the Fair Work Act since its inception. And what we'll look to do today is to go through what we feel are some of the biggest amendments. The first and most substantial change to the industrial relations laws, in my opinion, is the amendments to fixed term contracts. There's an introduction by the bill to limit the use of fixed term contracts for substantially the same role to 2 consecutive contracts or a maximum of 2 years in total. If an employer contravenes this requirement, the end effect will be that the bill will automatically convert the fixed term agreement into a permanent employment relationship. This will have a major impact for employees, allowing them to bring out claims for unfair dismissal, notice of pay on termination, and also redundancy entitlements. There are some exceptions to the general rule that's been just discussed, and the onus will be on the employer to show that an exemption applies. The bill also prohibits an employer effectively trying to work around this exception to fixed term employment and hiring a new employee on substantially the same terms. Put simply, if the employee that you are employing on a fixed term basis has reached their 2 consecutive employment agreements or has been employed for a total of 2 years, you can't simply end their employment and employ a new employee on exactly the same terms and conditions, because that will also be in contravention of the Act. The next important topic that we'd like to discuss is pay secrecy, as it's been quite heavily scrutinised within the media. For that, I'll hand over to my colleague Mitchell, who will discuss these amendments with you.
Thanks, Haydon. There's been some significant changes in relation to pay secrecy provisions and equal pay under the Fair Work Act. The overarching goal of these provisions is to ensure that employees are paid the same to conduct the same work, regardless of gender. Pay secrecy provisions have now been prohibited under a general employment contract. Employees now have a workplace right to discuss their remuneration. The purpose is to ensure that if there are discrepancies regarding remuneration for employees performing the same role, that these will be identified and give an employee an opportunity to make a complaint regarding their pay. It is important to note that employers cannot take any adverse action to an employee who exercises a right regarding their remuneration or discusses their remuneration. Any adverse action against the employee will likely result in a general protections application, which can contain some significant financial penalties for the employer. Another significant amendment in relation to employment disputes is the change to the jurisdiction for federal courts to hear small claims matters. The Small Claims Tribunal previously had jurisdiction to hear claims up to the value of $20,000, which following the bill has been increased to $100,000. The key thing for employers to take from this is that the Small Claims Tribunal has less formality than the General Federal Court, and employees are more likely to bring a claim due to the informal nature of the proceedings. This court is not formally bound by the rules of evidence, and the amendment also gives employees the opportunity to claim back the fees associated with bringing this claim. I anticipate seeing a large number of claims made by employees for underpayment issues that fall between the value of $20,000 and $100,000, and employers will be forced to defend these claims without legal representation unless this is granted by the court. This ensures that employers need to be proactive in relation to their employment contracts and ensure they are not contravening any relevant modern award. I'll now pass on to Haydon to speak about the amendments to sexual harassment.
Thanks, Mitch. The bill also takes on board a number of key recommendations from the Australian Human Rights Commission for amendments to be made in relation to sexual harassment in the workplace. The amendments give the Fair Work Commission and the courts greater mechanisms for resolving sexual harassment allegations. Under the amendments, sexual harassment is now expressly prohibited, and employers have a positive duty to take all reasonable and proportionate steps to eliminate sexual harassment in the workplace. Also, the amendments apply to all workers. What that means is that it's not strictly in relation to employees, and it also encompasses contractors, subcontractors, volunteers, students, apprentices, and any other sort of engagement. If sexual harassment is alleged, The Act now permits a worker to make an application for the Fair Work Commission to deal with the dispute by either seeking orders to stop sexual harassment, effectively a prohibition on future conduct, and it also allows them to make an application to deal with the dispute and order compensation for past and future harassment by way of conciliation or mediation, or alternatively, if both parties consent, by the Fair Work Commission arbitrating the matter. If the matter does not resolve in the alternative dispute resolution phase, the Fair Work Commission will issue a certificate and the applicant will have up to 60 days to make an application to one of the federal courts to hear the matter. An intricate but positive step that I see in the Act is that the Act now allows for multiple victims to bring the claim together against the one alleged perpetrator. Thinking about it from a practical perspective, what this means is that the alleged victims will not need to give evidence on multiple occasions in multiple matters. They can give evidence once in one matter that's been brought jointly, and that will be as far as the traumatic experience is for them in terms of the court proceedings. Lastly, it's important to note that the Fair Work Ombudsman will also have powers to investigate employers who are not upholding their duties to actively prevent sexual harassment. There is also the doctrine of vicarious liability to be aware of, meaning that an employee or worker can name the employer as being a party to the proceedings in addition to the alleged perpetrator. In short, it could be found that the employer is vicariously liable or also liable for the actions of the alleged perpetrator. In conclusion, that what we encourage with these amendments coming to fruition is that all employers take an active step to review their policies and procedures in relation to grievances, and also active steps that they can take to prevent sexual harassment. It's also critical that employers give some education and promote the disclosure of sexual harassment or alleged sexual harassment so that it can be prevented, and that the employer is upholding their duty to take all reasonable and proportionate steps to eliminate harassment in the workplace. For our final topic, Mitch is going to have a chat about flexible working arrangements and the recent amendments there.
Thanks, Haydon. In relation to flexible working arrangements, particularly given the success that multiple businesses have experienced throughout the COVID period, there is an onus for employers to demonstrate a real reason why an employee who requests a flexible working arrangement cannot work from home. An employee who makes a request for flexible work arrangements will be entitled to a consultation with the employer to discuss the operational needs of the business and the employee's individual personal circumstances. If an employer rejects a request for flexible working arrangements, there needs to be a real reason as to why this is not suitable for the business. If a dispute arises between the parties, which cannot be resolved informally, an employee may, within 21 days, make an application to the Fair Work Commission to have the matter determined. It is important to note that employers will need to adjust their flexible work policies and procedures to ensure that, given the likelihood of further employees working from home, that they are still performing the inherent requirements of their roles. In conclusion, given the vast number of changes to industrial relations laws, we have drafted 3 articles which go into further detail in relation to each of the amendments. These articles also detail the changes to the building and construction industry and employee enterprise bargaining and agreements. Roberts Crosby Mortensen can help you with any questions that you have in relation to these amendments, and we offer a free 30-minute free case evaluation for employers to discuss the needs of your business and what may be done to safeguard you against potential employment disputes.